Good morning, everybody. Thanks for joining Mayor Brown's Global Financial Markets teleconference series. Today's call is entitled CFPB's First Redlining Action Against the Non-Bank Lender, Key Takeaways. My name is Jim Williams. I'm an associate in Mayor Brown's Washington, D.C. office, and I'm also a member of the Consumer Financial Services Group. My practice focuses on representing companies that offer various consumer financial products and services, and I regularly work on matters involving fair lending, student loans, and education finance, mortgage lending, auto lending, and working with other consumer financial services companies. So first things first, a couple of housekeeping items. As regular listeners will know, this call is being recorded. We'll be emailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording will also be available as a podcast on your preferred podcast platform. And since we will not have a Q&A session, please send your questions regarding today's topic by email to gfm@mayorbrown.com, and we will respond promptly. This is the same email address as in your invitation email. So joining me today is my colleague, Tori Shinohara. Like me, Tori is a partner in the Washington, D.C. office and is a member of the Consumer Financial Services Group. She practices in the areas of mortgage banking, consumer finance, and concentrates on representing clients in connection with federal and state government enforcement matters and counseling clients on compliance with federal and state consumer financial protection laws and regulations, including fair lending. So with those brief introductions, we'll now begin today's discussion. So first things first, I'll provide a bit of an overview on the action against Townstone Financial, which is the CFPB's first redlining action against the non-bank lender. So on July 15th, the CFPB filed a lawsuit against Townstone Financial, which is a Chicago-based mortgage lender and mortgage broker. That lawsuit alleges that Townstone redlined African-American neighborhoods in the Chicago Metropolitan Statistical Area and discouraged prospective applicants from applying to Townstone for mortgage loans on the basis of race. Redlining actions against banks are relatively common. They've been brought in the past, and regulators have struggled to untether redlining claims from banks' obligations under the Community Reinvestment Act. Non-banks don't have to comply with the CRA, so the CFPB has been searching for some sort of a different hook for redlining claims against non-banks. And notably, this is the first time a federal regulator has taken a public redlining action against a non-bank mortgage lender. And in this action, rather than focusing solely on geographical or statistical hooks for liability, the CFPB instead has argued that the totality of the circumstances evidences unlawful redlining. So this action serves as a warning shot for two main reasons. It shows that the CFPB's current leadership is serious about bringing redlining claims, which is something they've stated publicly, but they haven't been really doing in earnest in recent years. And the action also demonstrates how federal regulators will analyze non-bank mortgage lenders' compliance with fair lending requirements, which is especially important because non-bank mortgage lenders are increasingly originating more mortgages by volume annually than depository institutions. So during this GFMI call, I'll provide an in-depth summary of the CFPB's claims against Townstone and its new theory of liability. My colleague Tori Shinohara will also discuss this new theory of liability and the implications of the CFPB's action for non-bank mortgage companies. So a bit of background on redlining and anti-discrimination law in general. The main anti-discrimination laws applicable to lenders are the Fair Housing Act and the Equal Credit Opportunity Act. The CFPB does not have enforcement authority under the Fair Housing Act. That belongs to the DOJ, the Department of Justice. So this lawsuit against Townstone only alleges violations of ACOA. ACOA and its implementing regulation, Regulation B, are broad anti-discrimination prohibitions that prohibit creditors from discriminating against any credit applicant in any aspect of a credit transaction on a prohibited basis, which includes race, among other things. So this prohibition, it also includes statements, acts, or practices that would discourage a reasonable applicant or a prospective applicant from applying for credit on a prohibited basis. The Department of Justice has previously defined redlining as, quote, an illegal practice in which lenders intentionally avoid providing services to individuals living in predominantly minority neighborhoods because of the race of the residents in those neighborhoods. But the key thing to note is that redlining is discrimination through geographic exclusion. So in other words, redlining exists where lenders do not provide adequate services to certain geographies because of the characteristics of the people living in those geographies. So In turning to look at this specific action against Townstone, the CFPB's complaint against Townstone effectively raises three different categories of allegations against the company in support of the CFPB's claim that Townstone avoided meeting the credit needs of predominantly African-American neighborhoods in the Chicago Metropolitan Statistical Area. First, the CFPB alleges that the company's owners and other senior management made disparaging remarks about African-American, predominantly African-American neighborhoods and women on a program called the Townstone Financial Show, which is an AM radio show and podcast. As the CFPB noted in its complaint, the company generated most of its mortgage loan application volume from that podcast, and the company has also stated that it's broadcast this radio show and podcast throughout the Chicago Metropolitan Statistical Area, through AM radio. So the CFPB highlighted 5 different instances from 2014 to 2017 in which a member of the company's senior management made comments on the show that the CFPB believes would discourage prospective applicants from applying to Townstone for mortgage loans on the basis of race or the racial composition of a neighborhood. So, for instance, in one case, Townstone CEO stated the south side of Chicago between Friday and Monday is, quote, hoodlum weekend, and that police are, quote, the only ones between that turning into a real war zone and keeping it where it's kind of at. So the CFPB looked at that quote and they said that referring to a predominantly minority geography as being, quote, hoodlum weekend over the weekend would have the effect of discouraging people living in that geography or those looking to live in that geography from applying for a mortgage loan with Townstone, and that violated ACOA. In response to those allegations, Townstone has asserted that it's being punished for voicing conservative political speech. So in various interviews and media appearances, lawyers for Townstone have noted that it advertises on a conservative-leaning radio station, that its owner and staff engaged in speech with which liberals disagree, and that the CFPB's case is principally based on those facts. Townstone has also noted that it specifically advertised on AM radio to reach as broad an audience as possible, and it has also, gone as far as to note that it hasn't received any fair lending complaints in its 18-year history. The CFPB's second category of allegations focused on Townstone's failure to affirmatively market to African Americans and its failure to employ any African American loan officers. So specifically, the CFPB alleged that Townstone made no effort to market directly to African Americans, even though African American consumers make up 17% of the population of the Chicago MSA. By the CFPB's own admission, though, Townstone broadcast its radio show throughout the entire Chicago MSA, made it available online as a podcast, and shared it widely in social media through Townstone's Facebook, Twitter, and LinkedIn accounts. That radio show was where Townstone drew most of its application volume. So, again, they marketed throughout the entire Chicago MSA. And typically, marketing-related allegations in past redlining actions have focused on claims that the bank either excluded majority-minority areas from its marketing strategies, or it selectively included predominantly white areas, for instance, by sending pre-screen offers for credit to those areas. But here, the CFPB is really only alleging that Townstone didn't affirmatively market, to African-American consumers, not that it excluded African-American consumers or African-American geographies, or that really only included certain majority white areas in its marketing strategy. The CFPB also noted that Townstone employed 17 loan officers during the applicable period, but that none of them were African-American. Even though the CFPB implies that the demographics of Townstone's sales force evidences a failure to serve African-American communities, the Bureau's complaint doesn't allege that the company actually discriminated against any mortgage loan applicants on the basis of race or ethnicity. So in a typical redlining action and in one of the Bureau's previous actions, the Bureau used testers to bolster its claims of redlining by alleging that African-American testers were treated less favorably than similarly situated white testers when attempting to apply for mortgage loans at bank branches. That isn't the case in this action. There's no allegations of actual discrimination. Here, the actual discriminatory conduct by loan officers in Townstone. The CFPB has also acknowledged that, as we mentioned earlier, 90% of Townstone's mortgage loan application volume came through its radio show broadcast. So it's unclear whether having an African-American loan officer on staff would drastically change the company's ability to generate mortgage loan applications from African-American applicants and in predominantly African-American areas, because most consumers were applying for loans to Townstone on the basis of a radio program that was broadcast throughout the entire metropolitan area of Chicago. The CFPB's third and final category of allegations focused on statistical analysis of Townstone's mortgage loan application volume. And it's important to note, Townstone's a pretty small mortgage company, so they received an average of 740 mortgage loan applications each year during the applicable time period. And the CFPB's complaint asserts that during that time period, Townstone received between 1.3% and 2.3% of its total applications for properties in majority African-American neighborhoods, as compared to between 7.6 and 8.2% of applications received at peer lenders. So in other words, Townstone's peer lenders allegedly received between 3.6 and 6.2 times more mortgage loan applications from majority African-American areas in the Chicago MSA than did Townstone. However, in many cases, it's somewhat difficult to identify peer lenders. So, for instance, should a small lender like Townstone be compared to a small depository institution that has branches, when Townstone, doesn't really function through a branch model? But the CFPB and DOJ, when they're looking at redlining and they're trying to identify peer lenders, they typically use a 50% to 200% volume threshold to determine similar institutions or institutions that have received similar overall mortgage loan volume. Mortgage loans in a particular census tract are also finite. So many depository institutions offer something called a special purpose credit program, and that helps them meet their CRA obligations. But it can be difficult for smaller non-bank lenders to compete for loans in those areas without having a special purpose credit program. And smaller lenders also can sometimes struggle to compete on pricing. So based on all the facts above, the CFPB alleges that the totality of those facts demonstrates that Townstone redlined African-American neighborhoods in the Chicago MSA and discouraged prospective mortgage applicants on the basis of race. So turning to the CFPB's theory of liability here. As we noted earlier, this is the first public redlining action against a non-bank mortgage lender by any federal regulator. Although depository institutions have historically originated the vast majority of mortgage loans by volume, in the past decade, non-bank mortgage companies have been increasingly gaining market share. Redlining claims have historically been brought against those depository institutions, and regulators have really struggled to come up with a clearly articulated theory of liability to bring a redlining claim against a non-bank. So in claims against depositories, regulators have alleged that redlining has occurred based on statistical allegations and other factual allegations. So typically the other factual allegations to support claims of redlining are centered on banks' delineation of their Community Reinvestment Act assessment areas. Under the CRA, every depository institution has to designate an assessment area or assessment areas, and once a depository institution designates that assessment area, it has to act to serve the credit needs of the entire area. So that includes low and moderate income areas, and those low and moderate income areas often overlap with predominantly minority areas. Unlike banks, however, non-banks don't have to comply with the CRA, and they have no affirmative legal obligation to let in any specific geography. So as a result, regulators have kind of struggled to figure out how to bring redlining claims against non-bank lenders when they don't have CRA performance to look at. And in its complaint, the CFPB appears to leverage a new concept called REMA, or sort of creating a proper assessment area to suggest that Townstone was required to serve the entire Chicago MSA to the same extent as if it were Townstone's designated CRA assessment area. So in other words, the Chicago MSA here is standing in as an assessment area for Townstone, even though Townstone doesn't have to designate a CRA assessment area. And by unmooring itself from this traditional legal framework for redlining allegations against depositories, the CFPB endorses a more flexible totality of the circumstances framework for redlining allegations against non-banks. So now I'm going to turn things over to my colleague, Tori Shinohara, and she'll discuss key lessons and compliance takeaways from this action.
Thanks, Jim. I want to spend a little time now talking about some of the key takeaways from the Bureau's lawsuit. As Jim highlighted, the most notable aspect of this action by far is the fact that it's the first public redlining action brought by a federal regulator against a non-bank. Although we know that the CFPB and the DOJ have both investigated non-bank lenders in the past for potential redlining, none of these investigations has resulted in a public action until now. And part of the reason that the DOJ and the CFPB haven't brought any public redlining actions to date is because they've had to come up with a workable framework for analyzing redlining claims against non-depositories that didn't focus on leveraging those depository institutions' lending obligations under the CRA, which is what they've typically done in the past. One other thing that I wanted to point out at the outset is that this is only the third redlining action brought by the Bureau since it came into existence in 2011. Prior to the CFPB's inception, however, the DOJ brought and settled a number of redlining cases dating back to the early 1990s, and they've also brought their own separate redlining actions since the CFPB came into existence in 2011. But with respect to the Bureau's prior redlining actions, both of the other redlining actions settled prior to the initiation of a lawsuit, and both of those cases were joint investigations and settlements with the DOJ. Under ECOA, the CFPB and the other prudential regulators have a statutory obligation to refer a matter to the DOJ if they believe that a pattern or practice of discrimination has occurred. And it's relatively common in redlining investigations for the DOJ to join the investigation upon receiving a referral from the CFPB, because the CFPB often has done a lot of the legwork to develop a case. But it's interesting to note that the DOJ didn't join this action. The CFPB and the DOJ have coextensive ECOA jurisdiction, meaning that they both have the ability to bring enforcement actions and lawsuits independently for violations of ECOA. In contrast, the CFPB doesn't have the authority to enforce the Fair Housing Act because it's not one of the enumerated federal consumer financial laws under the Dodd-Frank Act. So the DOJ alone has the authority to bring an action for a violation of the Fair Housing Act, and they chose not to exercise that authority in this case. Practically speaking, though, the fact that the DOJ isn't a party to the lawsuit doesn't impact the Bureau's ability to seek particular remedies, because the Bureau has its own broad authority under the Dodd-Frank Act to seek damages and civil money penalties for violations of ECOA alone. So to understand the significance of the allegations and some of the lessons learned from the Bureau's complaint against Townstone, I wanted to take a step back and briefly compare the allegations in the Bureau's complaint against Townstone to the allegations in the Bureau's two previous redlining settlements from 2015 and 2016. So the Bureau reached its first redlining settlement in September of 2015, and this settlement required the target bank to pay a little more than $27 million in loan subsidies, marketing-related costs, and consumer education in order to resolve allegations of redlining. And in that case, both the CFPB and the DOJ joined the investigation, the settlement, and they alleged that the target bank redlined certain minority communities in New York, New Jersey, Connecticut, and Pennsylvania. The complaint included allegations related to the location of physical bank branches, the demographics of the loan originators, and they also include allegations related to limited marketing to majority minority communities. The consent order also required that the bank open 2 new branches in majority minority areas. The Bureau reached its second redlining settlement in June of 2016. In that settlement, the target bank agreed to pay more than $10 million in loan subsidies, targeted marketing, and restitution for discriminatory pricing practices. This was also a joint action with the DOJ, and this particular action arose from alleged redlining in Memphis, Tennessee. In addition to allegations of redlining, in this case, the CFPB and the DOJ also alleged that the target bank had engaged in discriminatory underwriting and pricing practices, and the complaint cited as evidence of intent to discriminate and to redline certain racially insensitive statements that were made by bank employees in a meeting that was recorded, as well as the results of mystery shopping by testers. The results of mystery shopping at certain bank branches allegedly demonstrated that the bank treated non-Hispanic white testers better than similarly situated minority testers who visited bank branches and pretended to be interested in applying for a mortgage loan. The complaint also alleged that the bank's direct mail and marketing through individual loan officers, who were predominantly white, didn't sufficiently penetrate minority communities. And as part of the settlement, the bank was required to open a new branch in a majority African-American area of Memphis, in addition to one that they had already opened during the investigation. So how does the Bureau's lawsuit against Townstone compare to its two previous redlining actions? Well, it's standard in redlining cases, and it's the case in all three of these, that statistical allegations are really at the heart of the redlining allegations. In addition, all of the Bureau's redlining complaints have made some sort of allegations related to marketing and advertising, as well as the demographics of the lender's employees, meaning their loan originators, or in some cases, the mortgage brokers they did business with. So if a lender finds themselves in a position of trying to defend against potential redlining allegations, looking to past actions to see some of the tools that may be persuasive can be useful. And some of those tools that could be persuasive in defending against a redlining action are, first, market penetration performance. That's either on par or better than peers. Again, the importance of properly defining peers here can't be overstated. Two, having a diverse workforce, and especially a diverse sales force, because those are the individuals who are out and are interacting directly with the customers or the consumers and prospective applicants. And then three, having a comprehensive marketing strategy that's designed to reach all segments of the community in the lender's service area, however the lender defines that. So those are kind of some of the takeaways from what's similar about the past three redlining actions that the Bureau's taken. But what's different, what's new and different about the allegations that the Bureau is making against Townstone as compared to its previous redlining actions? Well, as Jim mentioned, the most notable thing is that, this is a non-bank for the first time, and therefore there are no allegations related to the delineation of assessment areas or CRA performance. But setting that aside, in this most recent action, this is the first time that the Bureau has taken issue with specific statements made by a lender in advertising, rather than simply taking issue with the lender's overall marketing efforts. This is also the first time that the Bureau hasn't made allegations related to the location of physical branches. And this could suggest that the Bureau is recognizing the declining importance of brick and mortar locations and the rise of online lending. Another key difference between this redlining action and the Bureau's previous actions is the size of the target lender. And I think this is one of the key takeaways from the CFPB's lawsuit, and that is, if you're a small lender, if you're a medium-sized lender, or if you only do business in one or two regions, you're not necessarily immune from a fair lending investigation. This lawsuit makes clear that you don't have to be a big bank to find yourself in the CFPB's crosshairs and to find yourself as the target of a fair lending investigation. According to Townstone, it only had 6 employees until about 2018. And during the applicable period of the complaint, which was 2014 to 2017, the company only was averaging approximately 740 mortgage loan originations a year, which equated to about $177 million in loan volume. So not a lot. This wasn't a huge lender. And then in 2018, Townstone became a mortgage broker, and now, as they've stated publicly, they only have 2 employees. So this is a smaller player in the market. So if you're a small or medium-sized lender, you might be asking yourself, how do regulators find targets for their investigations? And then how can you avoid trying to become the next target? There are several ways that a lender can appear on the CFPB or the DOJ's radar from a fair lending perspective. So first, the CFPB and the DOJ have their own statisticians on staff, and they use software to conduct their own analytics around HMDA data that's reported to the Bureau every year. The regulators will look at the data for patterns or outliers that may be concerning to them based on the data. Another way that you can become the target of a fair lending investigation is based on a fair lending exam. So if a CFPB examiner believes that there's a fair lending violation or a potential fair lending issue, they can refer the matter to enforcement for further investigation and further action. Another way that fair lending investigations can start is through complaints. So either consumer complaints or complaints by consumer groups. And in several investigations that I've handled, a consumer group has used publicly available HMDA data to perform its own fair lending analysis and then use the results of that analysis to either file a complaint or to bring it to the DOJ or the CFPB or a state agency and ask them to investigate based on that analysis. Finally, another way that a regulator can decide to focus on a particular lender is as the result of advertising and marketing. It's important to remember here that regulators and plaintiffs' attorneys are regular people who are living their everyday lives among us. And if they see something out there in the public domain that they think is problematic or it's potentially discriminatory, it could potentially be enough to put you on their radar. Now, it's not clear from the complaint how the Bureau's investigation started, but another key takeaway from this lawsuit is that if you as a lender put out marketing or advertising content into the public domain in any form, whether it's through radio, direct mail, social media, a podcast, a Super Bowl ad, what have you, that is now fair game for regulatory scrutiny. And with modern technology, especially in the social media context, all of this content is saved out there forever, and someone can always look back years from now and review everything that a lender has published, for example, on its Facebook page with a fine-tooth comb. So there are really two parts to ensuring that your marketing and advertising efforts don't inadvertently run afoul of regulatory expectations. First, are you as a lender ensuring that everything you disseminate publicly could withstand regulatory scrutiny if broken down to its individual components? So for example, each individual social media post, each individual direct mail piece, or in this case, each statement on a radio show or podcast. If a regulator were to view each of these individually, would they take or could they take issue with it? And then the second piece of a compliant marketing strategy is whether you have a comprehensive marketing strategy that as a whole is designed to reach all segments of the communities that you serve. So if a regulator were to view your marketing strategy overall, would they be satisfied that you are reaching, or at least attempting to reach, all segments of the communities that you lend in? We also know that the CFPB and other regulators, including the Department of Housing and Urban Development, have been focused recently on issues of digital redlining, which is the use of new technology to redline or exclude, either intentionally or unintentionally, certain populations of consumers, and typically communities of color. So if you're using new technology like models, machine learning, lookalike audiences, consider whether it's been appropriately vetted through a fair lending lens. So these are some of the key takeaways from this particular action, but this case was filed just last month, so it'll be a little while before there are any significant developments. But this case has the possibility to set new precedent for future redlining cases. Because most redlining cases ultimately settle, there's very little jurisprudence involving allegations of redlining in mortgage lending. Although the complaint outlines certain factual allegations related to the potential discouragement of prospective applicants in connection with certain marketing statements, redlining really historically has been viewed as the refusal to do business in majority-minority geographies. So as a result, it's unclear whether the CFPB's allegations about the company's marketing and employment practices, coupled with its allegations about statistics, will be sufficient to prove a redlining claim under ECOA in a court of law. We'll continue to monitor this case and will provide updates on further developments. Thanks to our audience for tuning in. A few brief reminders. You'll receive an email with a link to the recording of today's call, and the recording will also be available as a podcast on your preferred podcast platform. Lastly, as mentioned before, if you have any questions related to today's content, please email them to gsm@mayorbrown.com. Thanks again for your participation. You may disconnect now.